Good afternoon, and thank you for joining us for an MP webinar covering 2023 New York legislative updates, regulatory alerts, and guidance. I'm Brianna Hostler, marketing specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I am excited to introduce your presenters for today's program, Paul Carelis and Melissa Brown. Paul has over a decade of experience in the HR consulting space, working with businesses of all sizes and industries. Paul leads a team of SHRM certified HR professionals at MP. Together, they assist clients with compliance, training, and HR guidance and support for the full employee lifecycle. Paul also spearheads MP's employee retention tax credit services. This initiative has helped thousands of clients claim over $100 million in refundable, advanceable tax credits. Melissa is a dedicated, results-driven professional with over 20 years' experience in not-for-profit leadership. Prior to joining MP, Melissa spent over a decade as the Chief HR Officer for a $300 million, multifaceted, growth-focused, not-for-profit offering a prolific record of organizational development, HR, workforce development, operational leadership, and engagement achievement to deliver high-quality outcomes. A reputation defined by vigorous leadership, exceptional partnerships, and the delivery of sustainable year-over-year results, Melissa is passionate about working alongside leaders to foster high-performing, productive, motivated cultures that are aligned with companies' goals and values, while ensuring legal and ethical practices are followed. Just a few housekeeping items before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out the recording of the webinar later today along with the slides. And with that, I'm going to hand the mic off to Paul and Melissa.
Great, thank you so much. So great to speak with you today. Just before I dig into my full intro, a quick legal disclaimer. Melissa and I are, as was mentioned in the intro, passionate HR professionals. We are, however, not attorneys. So this presentation is intended from an HR best practices perspective and should not be construed as legal advice. So whether you're a longtime New York employer headquartered there and been doing business in the state for several years or decades, or maybe you're a new business, new to New York and just starting up operations, or maybe you're an employer from out of state who either during the pandemic or outside of the pandemic times decided to hire some workers in the state of New York, either to work in the field there or maybe remote workers working from home who just happen to reside in the state. Either way, it's really important to get a handle on all that's going on there. It's always been a regulation and regulatory heavy state. They've been on top of labor laws. They're considered one of the leaders in terms of progressive employment laws in the country, along with a few others. And this year has been no exception. The legislature in New York really passed a big flurry of legislation towards the end of their legislative session this summer, some of which has been signed by the governor, some of which has yet to be signed. So we will differentiate between that. But what we hope to cover in today's session are the legal updates that are currently in effect. So some new things that recently passed or have been signed. I'm also going to talk a little bit about some stuff that did pass the legislature, but has not yet been signed by the governor. So just some stuff to tentatively be prepared for so that if she does apply her signature to that bill, it'll be all systems go and you'll be feeling prepared to comply with whatever it may be. And then we'll close with a few federal items that will affect employers both in New York and around the country, and just some new things to be mindful of there. So I'm super excited to introduce Melissa for this presentation. Very grateful to have her on our team. She is New York based and a true exceptional HR professional, just with a wealth of knowledge and just a real knack for helping employers stay in line when it comes to some of these really, really complex and complicated rules. So I will hand it over to you, Melissa.
Awesome. Thank you, Paul. And I am so excited to be here for my first MPHR webinar after spending several decades being an employer in the state of New York. I can echo the complexities that all of us on this call are navigating on a daily basis as we have a workforce here in New York. And thanks for joining us. Today, we're going to help you navigate some of these legislation and labor laws that have impacted your businesses and employers who employ people in New York State. As Paul mentioned, there's a series of important updates that have come into effect. They will have significant impacts and considerations for employers. So not only will we talk about some of these specifically, I will give some best practice recommendations after spending decades, in-house as a CHRO. The lens that I like to take with some of this, again, we're not lawyers, but what does that mean to us as HR professionals or business owners that have to navigate some of this stuff that comes at us in the state of New York? So without further ado, the hottest topic around right now that I think should be of no surprise, hopefully, to all of us in New York is pay transparency. So pay transparency, it is a hot topic across the United States. New York has now joined this conversation. So hopefully everybody on this call has started to use their postings and put pay transparency in effect, because it is now required for New York employers with 4 or more employees to include compensation details in their job postings, even if they are for internal postings and positions. So what does that mean? Postings have to include reasonable compensation ranges that are representing good faith estimations of your pay, and it has to include a minimum and maximum annual salary or hourly rate. Additionally, pay transparency requires employers to post accurate job descriptions that include the essential functions of the job, qualifications, skills, and competencies that are needed to perform that job. The law is promoting transparency, it's helping to mitigate wage disparities, and also raises a lot of important considerations for New York employers. The first being pay equity. This is crucial for us to explore. Employers need to be prepared for potential claims if disparities emerge from having transparency with their pay practices. Compression is another concern. When you're raising wages for one group, it can have ripple effects, potentially causing some equity issues and for pay grades to bump up against each other. So it's really important, as you are compliant with this, to think about your workforce and the implications that this has, not just externally from a competitive advantage, but also internally to the morale and culture within your workforce. So we want to look at this from an equity standpoint, a compression standpoint, and we really recommend, employers at this time doing a full compensation analysis using credible market benchmarking sources. Not only will it give you that competitive advantage, but it's going to make sure that you're aligned, with this law. That is super important. It does apply to opportunities outside of New York State where you have a supervisor in office or people sitting in New York State. So be careful. Again, as Paul mentioned, during the pandemic, many of you have had employers and employees all over, but have done business in New York and have people sitting in New York. So these things have to be compliant. New York is joining 17 other states, so chances are, if you're a multi-state employer, this is going to come across your way if it hasn't already. So pay transparency, hopefully everybody is now fully compliant with this. Again, if you're not and have any questions, now's the time to put them in the chat and ask us, but this will definitely cause some things inside your businesses that you want to start looking at. Wage theft is a serious issue. I think all of us can agree on this call. It has been a point of concern for some time, many, many decades in the state of New York. Recent legislation has made it even more significant for New York employers. So over the past decade plus, New York lawmakers have passed several laws intended to combat perceived wage theft that's across the Empire State. So recently, all the lawmakers in Albany continued this trend by passing a bill that now codifies wage theft as criminal larceny. What does that mean? Employers failing to pay wages as mandated by law could now face criminal penalties. So wage theft, as defined by the law, is when an individual is hired to perform services, carries out those duties, and yet the employer fails to compensate them at the minimum wage rate or overtime as mandated by New York State wage and hour laws. Specifically, what this law did is the governor amended the New York penal law to change it to a larceny statute. So wage theft now is described as a person who performs these services and makes it part of the penal law, that if they are underpaid or non-paid, that they can have criminal prosecution now. And prosecutors are able to be a lot more aggressive with how they're charging employers with wage theft under the wage and hour laws. So if you are an employer and you fail to timely pay and fully pay all your wages that are due to employees, in addition to all the civil penalties that were pre-existing and those damages, you now are subject to criminal penalties under the New York State penal law. So it's really, really, really important. Right now is the time, and I know you've all heard this before, right now is the time to start looking at your policies and records. Ensure that you have good practices, ensure that your policies are updated and align with what the wage and hour laws are. Review them and make sure you're keeping precise, meticulous records of your employees' work hours, wages, and compensation. This is critical at this time. This will help you substantiate compliance with the wage and hour laws and make sure that you are also self-auditing and being proactive before a claim comes your way. And the best recommendation that I can give is to implement training programs for your managers and your HR personnel to ensure that they possess a comprehensive understanding of labor laws and compliance requisites when it comes to wage and hour. For those of us that have been operating in the state of New York for some time, we know that wage and hour is the number one or close to the number one source of claims in our state. The more we are transparent with communicating our employees regarding wages and overtime policies and entitlements, although thinking it may cause some issues and morale issues, it's super important to start adopting these transparent communications so it does not lead to any misunderstandings or disputes. So the more you can communicate with your employees about how they're paid, their entitlements, and what they receive for the work they perform is going to be super important in New York State right now. And as everything that comes through with wage and hour, we can definitely expect an uptick in audits and wage claims. So again, it's real critical to be proactive with some of this stuff. Minimum wage increase is coming. So this is again published pretty much every year and has had a wage scale for the past several years here in New York. The governor has made it official where the minimum wage will be increasing. So starting in January 1st of 2024, for those employers that are in New York City, Westchester, and Long Island, your minimum wage will be $16 an hour as mandated by New York law. For the rest of New York, it is officially coming in at $15 an hour. And you can see on the slide in 2025, it'll go up 50 cents, and then in 2026 another 50 cents, and the governor will then look at the wages thereon after 2026 against the market, and the minimum wage will be published on October 1st each year, and that will take effect on January 1st. So for those of us that have been watching minimum wage in New York State for a really long time, this is now official and put into practice for the next 3 years. We have our guide of what we should be paying. So what does this mean? Again, considerations for our New York employers. Again, now is the time to make sure you're reviewing your pay. Pull your payroll records, make sure that you are compliant with anybody who is not making minimum wage. Now is the time to start bumping them up. Do workforce planning and prepare for some of that. Make sure you're looking at, again, compensation analysis. It's a really good time to see what's out there in the market. This is a good time to get competitive advantage. For those of you that, financially can do so, paying above minimum wage is always a great recommendation, but keeping that minimum wage is super important right now. And again, think about compression. When you're complying and raising wages, it's always good to look at the levels and the people who are paid close to that $15 an hour to make sure that you're not having compression issues and you don't need to address their pay as well. Along with minimum wage, the workers' comp benefit has increased. So again, in New York State, where we are very focused on protecting workers' rights, this new bill has emerged that is aimed at enhancing that safety net for people who are injured on the job. And the goal of this really is protecting especially those low wage earners. So as of now, the minimum weekly benefit was last updated in 2013, and it stands at about $150 a week, and that is increasing. And we will now see that increase across the way in 2024 to $275. And they have officially put out in 2025 that weekly benefit will increase to $325 a week. This bill, again, was aimed at increasing that minimum weekly compensation for claimants who rely on these benefits for injured workers. It's a progressive increase to the benefits for both permanent and temporary partial disability. So again, when you're looking at the weekly benefits, we have that they're increasing $275 in 2024, $325 in 2025, and by 2026, they are pegged to look at 1/5 of the state's average weekly wage. So that's how they will calculate that. And this bill is definitely aimed at ensuring that the workers' earnings are less than those that are less than 1/5 of the average weekly wage, that they're getting full wages if they're injured on the job. So just some slight increases to the workers' comp benefits. So it's really important for you to talk to your workers' comp carriers, for New York employers to work with these carriers, to start thinking about your safety program, your wellness programs, your education to workers. Do you have things like return to work policies and procedures in place? Does your HR staff or the personnel responsible for workers' compensation and injury at work, are they aware of the benefits? It's while it may seem slight, can have some significant financial impact, especially if you're paying out indemnity and people aren't returning to work. So just wanted to make sure you were aware that the compensation for injured workers is going up along with minimum wage in 2024. So artificial intelligence, that is another hot topic. So, we joke around here, other than pay transparency, it seems like AI, those are the two magic words, the buzzwords that are floating around in the human resources world. And we know artificial intelligence, it's on rise everywhere, right, in our lives. And it shouldn't really surprise us that lawmakers are looking at artificial intelligence and employment decisions under a closer lens. The legislation has scrutinized artificial intelligence bias in laws. So in New York City only, so I just want to make sure that that's very clear that starting in July 5th of this year in New York City, there is an AEDT law, which is basically took effect in January, and that is basically restricts the use of those automated employment decision tools. That's what AEDT stands for. And requires these employment agencies and employers to make sure that these tools are not subject to bias, and requiring them to notify employees and job candidates that these tools are being used to evaluate them. And that's really critical in the law, that there has to be a notification there. Any failure to comply with this new law, which is now mandatory again and for any company operating and hiring in the New York City area, could result in fines starting at $500 with maximum penalties up to $1,500 per instance. So it's really going to be important, if you're using any of those AEDT, those automated employment decision tools, for your hiring and selection process in New York City, that you are complying with the disclosures that have to be given to your candidates. And now you might be thinking, my company doesn't have offices in New York City, so I don't really care. We don't use AI, so I don't really care. These laws don't apply to me. However, you may be wrong. So regardless of the office locations, we know that the rise of remote work is increasing. So there is possibility of candidates in New York City applying for roles that are in non-local organizations. So a law like this could still be coming either to a city like you, or could impact depending where your worker sits in the state, or across the country. So again, don't think in your just zip code this is affecting anybody who is hiring workers and they're sitting in the New York City area. And we also know, for those of us not in the New York City area, that upstate typically follows suit when it comes to these employment practices. So we can expect that this will probably be coming to the rest of the state in the near future. So it's really a great time for employers to review their talent acquisition strategies, their processes, see how they're using AI in selection. And again, even if you're in upstate New York or you're outside of New York, it's really good to start looking at these, because there is an uptick in trends in the laws happening, nationwide. So although AI is a very, very powerful tool, we know as HR professionals it has to be equitable and fair. And we have to make sure we're not bringing bias into our selection process.
One quick thing, we will answer questions at the end. We'll have a live Q&A. One that I did just want to address live, there was a question about the effective date of this. I believe July 5th is the correct date. There was just a little a question on that, because the slide says November and July, but I believe July 5th is the
Oh, I'm sorry.
effective date
Yes.
there.
Yes, it is. Thank you, Paul.
All good.
Sorry about that.
No worries.
So here's our November effective. So that was probably ahead of myself there. So this is I would say, I don't want to use the word minor, but it's been a best practice, I think, for a lot of HR professionals. But the notice of unemployment is officially now a new rule in law that has it will take effect in November. These notices of employment rules in compliance is pretty common in other states, but effective November 14th in New York State, any New York State employer must provide written notice of rights to file for unemployment benefits to any employee whose employment has been terminated or whose scheduled working hours have been reduced. Employees must be informed of their right to file for unemployment benefits within 5 working days. So this is a crucial step in maintaining compliance and ensuring smooth transitions for your employees. This has been a requirement in other states. It's now time for us to look at this in New York. And my recommendation is to look at your offboarding practices and notices, make sure you're compliant. And again, making sure your managers and anybody, your HR personnel or those responsible for HR are aware. So anytime somebody is terminated, you have 5 working days along with their termination letter. You must now give a notice of unemployment when you are terminating them. And I will just add for that, there are some certain requirements that you have to have on that notice of unemployment. And typically in other states, we've seen templates come out, and that is probably will be the case in New York as well, but it has to have certain things like your employer identification number. And there's certain things that have to be in that notice. So I would just pay attention to that as well in upcoming months, and just look for that release before the November date. So social media, another popular topic, and sometimes a very difficult place for people to navigate, employers to navigate. We all live in a world that is very viral and digital and transparent. And employee social media privacy is protected under this new law. So employers may not request login information or retaliate against employees who refuse to comply. And this law basically is prohibiting employers from asking any of this information, requesting or requiring that employees or job applicants disclose any login information to their personal social media accounts. It prohibits employers from retaliating against anybody who doesn't comply. And this law really is emphasizing the importance of respecting personal boundaries in the digital age. So, again, and just making sure that as people are coming in to apply and working for you, that we don't have the right now, or hopefully it shouldn't have been a best practice, but if it was, I would recommend not doing that. Taking a look at your employee social media accounts, and that is defined as anything online. So it's not just a Facebook or an Instagram. It's if they have an online platform where they can add information, share pictures, share information. So think about that in the broader sense. And this law is prohibiting you as an employer to request any of that information as a condition of employment, or to have any of their personal account information on file, or reproduce photos, videos, or other information that's contained in their personal accounts under this law. So you have to be really careful with investigations and things like that. There are a few exceptions for employers and a few protections to think about. You are permitted as employers to seek access if you own the account. So if employers own that account, so if you have a marketing staff, for example, that is maintaining your company's Facebook account, you're able to request those logins and standardize that and make sure that they're accessible to more than just the employee managing it. So you do have some of those protections built in. And the most important thing to remember is to just provide the employee with prior notice of their right to request that information. So if it's part of their job and they need to maintain those accounts, or they have to put a personal PIN for their cell phone, or anything that's owned or required and managed by the company, you're still able to do that. It's when it's their personal account that really should be none of our business anyway as employers, that you want to be careful of. And now this is signed into law that prohibits people from doing that. So again, as a best practice, in consideration for our New York employers, it is the time to review your policy, your social media policy, make sure there is, it's matching and aligned with this law. Make sure we're training managers and leadership staff and HR professionals to not bring some of this stuff into employee management discipline practices. And if you are, make sure that your policies are saying things like that, so that employees are informed that this stuff could be used if owned by the employer. So captive audience meetings, that is another big piece of New York legislation and law that is now in effect. And the captive audience meetings have been under scrutiny, especially concerning labor union matters. So this law has taken effect immediately. It prohibits employers from requiring employees to attend meetings or listen to communications that have the primary purpose of sharing the employer's thoughts concerning religious or political matters. The law does not apply to supervisory or managerial employees. So the new law makes it unlawful for employers in New York to take adverse action against employees who are refusing to attend meetings or listen to communications where the primary purpose is to communicate the employer's religious or political views, including its decisions on whether to join or support a union. So employers have to navigate these meetings with extreme care and compliance, because there's a lot of governing bodies that will cross over here, not only the human rights law, but we have to think about the NLRB, and if you're unionized, what this means. But in general, if you're not unionized, we have to be really sensitive about these types of meetings in our workplaces, and making sure our employers and our management teams are aware of these requirements under the law. So again, for best practices and considerations for you to look at, are your policies, making sure that nothing is prohibiting these, and making it mandatory for employees to sit in on meetings of this nature, and really making sure that it's clearly articulated in your handbooks, and make sure your managers are trained in knowing that this is against the law, and we cannot make our employees sit in these types of meetings. Okay, an update to our New York agenda. So New York continues its commitment to inclusivity with the Gender Expression Non-Discrimination Act. So hopefully all of you know that gender has been part of our law since about 2019. And for those of you who are not aware of gender, it does protect gender identity and expression as a protected class in employment. The new law that has been amended includes unpaid interns under the protected category. So while we've had gender since 2019, and we have identified gender expression and identity since then in the state of New York, the amendment now brings this section of the executive law into conformance with other provisions of the human rights law that now include gender identity and expression protected for interns, both paid and unpaid, in our workforces. So a minor slight tweak to that law, but a super important one if you are bringing interns into your place of business. Again, before I turn it over to Paul, I'll add that considerations under this now, I would go back to your gender policies, your non-harassment and discrimination policies, make sure they're including the language about interns, as well as review any existing intern policies you have. And if you don't have them, I strongly recommend putting in policies and procedures of how you're handling interns. We're not going to get into it today. We could probably do a whole session on that, but I can tell you it is definitely a little trickier in our state. We can't just have interns come in without certain things put in place. So we want to make sure we're paying attention to that. So I do recommend developing those policies if you don't have them already in place. And again, just making sure we're training our managers that interns are included into that law. Thanks, Paul.
Awesome. Thank you so much, Melissa. That was really great roundup of things that are of immediate importance to employers or folks with employees in New York. So happy to take it from here in terms of some of the stuff that has passed the legislature or looks like it will, but has yet to be signed into law. So oftentimes in many states, you'll see that once something passes the House and Senate, the governor will either sign or veto it in fairly short order. And I'm not sure if it's just, part of negotiating or wanting some concessions or what it may be, or it might just be being overwhelmed with all this legislation that's recently passed. But there are several and fairly significant pieces of legislation that have passed but are sitting on the governor's desk awaiting signature. And for some of them, there are some guesses as to whether or not she will sign them. Others, it's really kind of unknown what the holdup is or whether it'll be enacted or not. But we'll dive into each of those separately right here. And again, feel free to throw some questions in the Q&A. Looks like we have some really good ones. If we don't have the answer offhand, we'll certainly do some research and get back and follow up with everybody. Looks like the ones that are in there right now, we should be able to address at the conclusion of the presentation. So the first we wanted to cover is the ban on non-compete agreements. So this really captured headlines across the country as one of the more aggressive bans on non-compete agreements coming from a state. We are seeing this pop up in several states now that are either putting restrictions on non-compete agreements in terms of who's allowed to sign into them. Some states will say that an employee has to be exempt versus hourly, or be in a certain role, or have a certain level of compensation, things like that. The New York ban, as passed, is much more comprehensive and creates a restriction or really a limitation of virtually any non-compete agreement. So if signed into law as is, there would virtually be no circumstances where an employer would be having a new employee signing a non-compete agreement. So the governor has expressed interest in signing a law that would give employees the freedom to work when, how, and for whom they wish, and give them that freedom and flexibility with their careers, but has not commented about whether or not she's going to sign this specific version of the bill. So this remains to be seen. If it does, I believe there's a 30-day period from when it's signed to when it goes into effect. So For all of those who registered for today's webinar, you are on our mailing list, so we'll be sure to be sending along updates as the news develops on this one. Next is what's known as the Freelance Isn't Free Act. So this is something that is in place in New York City and has been for 6 years now. But the state legislature passed a statewide version of this, pretty identical this summer. Again, still awaiting governor's signature. If she does sign it, there'll be a 180-day waiting period, so 6 months from when it's signed, if it is, to when it would go into effect. What this really aims to do is address some of those short-term, one-off or several small project workers and freelancers, just to make sure that they're not being taken advantage of, that they're being paid fully and timely and getting a full understanding of how much they're going to be paid and what they're going to be paid for. So if passed, just to go over the finer details, any freelance worker who's doing work that it's going to exceed $800, whether that be one project or accumulation of projects over a 120-day period, if that amount or value of those projects is going to exceed $800, they need to be given a written contract. They also will have a 30-day deadline to pay in full once the project is completed. It also creates legal ramifications for employers if they retaliate against freelancers for exercising any of their rights under this bill. In terms of record keeping, employers would be required to retain freelance contracts for a period of 6 years, and also puts an onus on the state to do an outreach campaign regarding this law and making sure that freelancers are aware of their rights should this go into effect. All right, next is a big one. So this non-disclosure and settlement agreements law is really aiming and will have an impact on businesses that have put agreements in place for employees who have claimed or been victims of discrimination, sexual harassment, things like that. Really what they're looking to do is reform those settlement agreements that often happen, again, when they involve sexual harassment or any type of discrimination. Again, this is awaiting the governor's signature, but will, if signed into law, have some real significant changes to the structure of settlement agreements when it comes to these types of cases. If passed, no longer would employers be allowed to include liquidated damage provisions if a claimant violates any sort of non-disclosure agreement. So it's really going to put the brakes on non-disclosure and non-disparagement pieces within these settlement agreements, and give victims the right to kind of have their right to speak out about whatever happened to them without any risk of legal or financial repercussions. They wouldn't also have to forfeit any of their settlement or consideration, anything like that. If signed, it will take effect immediately. So keep your eyes on that. If it does pass, it will be an immediate thing to be compliant with. Next is the Clean Slate Act. So this is another one that we're seeing pop up from state to state. So currently, New York does seal criminal records through the judicial review process. So, they can take them on a case-by-case basis, and if they decide that someone's record or record for a certain infraction should be sealed, and they go ahead and do so. What this would do would create an automatic system where after a specified period of time, depending on what the infraction is, would in fact seal those records automatically. Obviously, this would have effect on the ability for employers to do background checks on the information that they might see on those, as well as making decisions that are employment related. There are, various provisions within this bill. It's fairly lengthy that would exempt certain industries from, having a right to see this information. Types of industries that work with the elderly or work with children or other at-risk groups. There'll also be exceptions for certain types of crimes. Sexual offenders and things like that would not have automatic sealing of their convictions. So one to keep an eye on here to see if it passes as is, or if there are any changes before it goes into law. But this is something that's really sweeping, and we're seeing many states enact something similar in an attempt to allow people who do have past convictions to be able to enter the workforce with fewer hurdles if they've kind of got their act together. All right, so there are also some modifications of the clerical worker definition and exempt workers in the state of New York that are pending. So what this essentially does is raise the minimum salary amount for those workers. So that's currently at $900. And from what I understand, Melissa, sometimes that varies region by region within the state. But this would bump up that number in excess of $1,300 in order for someone to meet the exemption in New York. You will want to keep an eye, and we'll talk about it in a few moments when we do our federal roundup. But the federal government also has a proposal on the table to raise the minimum salary level for exempt workers. So New York has long been an exception to that national rule where they have their own salary standards set that are higher than the national minimum. So keep an eye on this, and especially as things progress at the federal level, to kind of see which one ends up being more beneficial to employees, because that's what you'll have to go with.
Hey, Paul, can I just interrupt? I
Yeah.
am going to, I think just because of the timing, there is a question that came through about the minimum salary exempt employees going up as it has in years past. So
Yep.
we'll keep the rest of the questions till the end, but just because of the relevance, and somebody did ask that question. So we know with the increase to the minimum wage, we can anticipate that happening. Everything we have seen thus far, there's nothing published. But if the historical salary basis threshold of 75 times the minimum wage is going to remain the same, we kind of can predict that the 2024 exempt salary threshold for, the New York City area, Long Island and Westchester will go up. And it currently sits at 58.5 annually or 11.25 weekly. So from some of the research and based on that, we're looking at it going up to 62,400 annually in that area, or 1,200 weekly. And then for the rest of the state, that exempt salary threshold for the remainder would increase in 2024 from 1,064 25 weekly to or 55,341 annually, to 1124 weekly or 58,500 annually. So that's just some historical context to answer that question. Although they are not published yet, those are not out officially by anybody in the government, but looking at that historical trend and how that's panned out, we can anticipate that going up at some point, I think in 2024.
Great information. All right, so as promised, did want to touch upon a few federal updates as well that are noteworthy. So first, at the Department of Labor, as I just said, they have issued a proposed rule to raise the minimum salary threshold before you even take a look at the job duties and the duties test of that salary, which would essentially bring it up to $55,000 per year as a minimum before you can consider job duties and whether an employee is exempt or not. So we are currently in the 60-day public comment period for that. So they've proposed the rule. There is now the comment period where the public and businesses and business groups can submit their thoughts and ideas on that proposal. The Department of Labor will then take those considerations, factor them in, and then come out with a final rule sometime after that period. One thing to note, there were several business groups that banded together earlier this week and submitted a formal request to extend the 60-day comment period to 120 days. DOL has not provided any comment on that as of yet as to whether or not they're going to grant that and extend the comment period. But as of right now, I believe the proposal was formally published and the clock started last month in August, which means that sometime in October that would currently expire. If it is extended, it would go to just before the end of the year. So in terms of timeline, while there are certain to be some legal challenges with it, ignoring those, if we follow a typical Department of Labor timeline, I would guess that we would get a proposed rule if we keep and retain the 60-day comment period right around the end of the year or sometime in January, and probably have a go live date for that new salary threshold sometime towards the end of first quarter or the midst of second quarter 2024. So again, something to keep an eye on, especially if you are an employer who has salaried workers making less than $55,000 a year. There might be some strategy that you'll need to employ to decide whether you're going to raise those people up to the new minimum salary threshold or if you're going to make them non-exempt workers and how that's going to go. The Department of Labor is operating technically without a formally approved secretary. So the previous secretary, Marty Walsh, did step down some time ago. His deputy secretary, Miss Sue, excuse me, did take over as the acting secretary. That was recently challenged as well, but the government oversight agency did just rule that she is within her power to make decisions on behalf of the Department of Labor, and that any rulemaking the Department of Labor does in this interim time period is still valid. Also, for just about everybody, you're probably familiar with the I-9 form. That is overseen by the Department of Homeland Security and serves two purposes: A, verifying employees' identities as well as their authorization to work in the United States. A standard form that should be part of your standard onboarding process. Just please do note that there is a new form now available, and as of November 1st, you need to start using that new form. The form that's currently in effect will no longer be allowed as of November 1st. They are also paving the way for the ability for employers who do use E-Verify to also be able to continue doing virtual inspection of substantiation documents for the I-9. We do have some information on that coming out, so keep your eyes peeled for that, but that is potentially an option for employers who do use E-Verify. And then finally, from the federal perspective, I did just want to send along an update. National Labor Relations Board, I believe Melissa mentioned them in one of her updates when we talk about captive audience meetings and things like that. They have been very, very busy. They are taking cases left and right and ruling decisively in ways very different than the past iteration of the National Labor Relations Board. So some of the more significant rulings that they've handed down over the last few months include a case involving employee handbooks. So that was through the company Stericycle. But, through that ruling, they issued some pretty clear directives and expectations when it comes to handbooks and handbook policies, and making it a point that it's crucial and vitally important that employers do not have anything overly vague in their employment policies or anything that can be construed as chilling to an employee's rights, especially their Section 7 rights under the National Labor Relations Act, which protects their protected concerted speech, as well as their rights to organize and hold union elections and things like that. So if you haven't very recently updated your handbook, or maybe if it was even earlier this year, anytime since those rulings came down this summer, you're going to want to do a new review of your employee handbook just to make sure it is in compliance and on the right side of what the National Labor Relations Board says it needs to be as of now. Some other recent National Labor Relations Board rulings, they weighed in on employee outbursts, especially if the circumstances surround an employee's rights, either covered complaints about their working conditions or heated conversations about unionizing or organizing labor union. Basically what they said is that when an employee does have an outburst, that you don't want to look at that in a vacuum against your standard employee policies, that you do want to look at it in the context of the situation. And if that context involves an employee exercising their rights under the National Labor Relations Act, then it may be covered speech. So do consult with an HR professional if you are having a disciplinary action or thinking about terminating an employee based on an outburst that they had. Also earlier this year, in case you missed it, they also weighed in on severance agreements, and specifically non-disparagement clauses in severance agreements. So with that, basically, if a severance agreement or a release of claims, as we often see, if any of us who have ever reviewed those will usually say there's some sort of mutual non-disparagement, that in order to get the severance payment, you, the employee or former employee, as well as the company, agree not to disparage each other publicly in any sort of way. Those, based on recent NLRB guidance, need to be very carefully and specifically crafted. Just a general non-disparagement in there is found to be unlawful and invalidates that release of claims that the employee signed. They also less formally weighed in on non-compete agreement, so they jumped into the fray. Basically, the general counsel for the National Labor Relations Board, who is a very powerful position, kind of opined that it's the board's view that, as a rule, non-compete agreements are unlawful and shouldn't be valued or treated as valid. They don't quite have the authority to make a formal law or decision on that. As you probably saw, the Federal Trade Commission also weighed in similarly and are trying to pass some regulations there. It isn't clear who, if anyone, has the authority to do that at the federal level, or at least through these federal agencies. But the National Labor Relations Board threw their log into that fire to say they're against them as well. And then finally, just in terms of something of perhaps not less importance, but maybe less applicability if you're non-union, there was recently a case where a business in New York, coincidentally, did grant non-union employees a holiday and did not do the same for the union folks because that holiday was not included in their collective bargaining agreement. The union cited unfair labor practices because the non-union workers did get the holiday, but the National Labor Relations Board voted in that case on the side of the employer and said that it was perfectly fine because it wasn't in the collective bargaining agreement that they did not have to give the union employees that holiday. All right, so I think that is our New York and federal roundup. Let's dig into some questions here. Right.
I can take the first one if you want
Sure.
while you're
Yeah.
okay. So the first question says, does pay transparency apply to higher education and secondary education? And the answer is yes. The only exemptions are for hiring employment agencies and government entities. So, and under the law and other areas, the higher education system is not falling in that government entity. So I would recommend you do comply with pay transparency if you are in higher education or secondary education employer.
Awesome. Thanks, Melissa. In terms of that second one, so the LS-54 form, if you remember from earlier in the presentation, that has to do with the Wage Theft Act. It's my understanding that that specific form does need to be filled out and signed, that having it in the offer letter would not be sufficient. Have you seen otherwise, Melissa?
Yeah, so it's got some, it's a little gray, but what
Okay.
I like to do is recommend exactly what you just said, just to have that compliance. But the law does require employers to give written notice of wages to each new hire, and that wage form, that LS-54 has all the things that have to be included. So for the sake of ease, it might be better, but it has to include your rate or rates of pay, including the overtime rate of pay. It has to include how the employee is paid, whether it's by the hour, shift, day, week, commission, etc. It has to include your regular payday, the official name of the employer, and any other names, DBAs that the business is doing, or names the business is performing under. It has to have the address and phone number of your employer's main office or principal location, and any allowances that are taken as part of the minimum wage. So that's the tips, meal, lodging deduction. So it has to be provided in both English and the primary language of the employee at the employee's request. So the easier thing to do is to make sure that that LS-54 is included, but an employer, according to the DOL, may provide its own notice as long as it includes all of those required elements that I just said. So again, if it does not in your offer letters, I would go back and look at them, or a good best practice is to just use the form.
Yeah, that's great to know. We have been working with some clients. The New York and really every state's Department of Labor has definitely stepped up with their audits, and just looking at some of the laundry list of things that employers have been required to furnish. That's always on that list of forms, but it is good to know that an equivalent is accepted.
Right. And just keep in mind too, again, under that the the Wage Theft Prevention Act. There's a lot of provisions in there that employers have to be aware of that has really strong whistleblower protections in it. So, as now we've talked about it being, amended in the penal law, it's really important that you're abiding to that in both, whether it's an offer letter or utilizing that form. Because with the penalties getting steeper and steeper in New York State, it's not going to be really negotiable, and it'll be harder and harder to defend for employers.
Awesome. And then in terms of a template for the unemployment notice, I think
Yes,
we
there
said we're
is.
expecting, there is one
Yeah,
now? Okay,
actually, I
great.
just hot off the press. I was
Nice.
looking at it. It looks like they do have a template. So it's IA 12 something, but I can either put it in the chat or make sure it goes out. But there is a record of employment on the New York State Department of Labor site that has all the requirements in it for the notice of unemployment that has to be furnished. So it does look like that something is already existing, or again, it looks like the equivalent you can do on your own, but that form is on the New York State Department of Labor site.
Maybe what we can do is when we send out a copy of the slides to all the registrants, we can include that in with that.
Perfect.
All right. The captive audience doesn't apply then to regular hands-on meetings with a standing operational agenda. No. So by no means does that rule or that law limit employers from having mandatory meetings when there's business need or, a justification to have a mandatory meeting for employees. Definitely not the case. It's just a matter of if you are having a mandatory meeting, just be mindful and make sure that there isn't a religious or political or anti-union agenda as part of it. And then if our business is headquartered in New York City, but we have an office in California, do we still provide employers with the notice of pay rate? Well, a couple of really tricky states. So my heart goes out to you in terms of trying to be in compliance there. You've got a couple of doozies, to be
Took the
completely
words out of
honest.
my mouth.
So I'd say for the employees that are working in the California office that aren't going to be working in New York, then they would not be required to have the New York wage theft. If they're reporting to someone in that New York headquarters, as Melissa very wisely shared, they'll be subject to the pay transparency laws. But California does happen to have its own pay transparency
Yes.
laws that you need to be in compliance with, and I believe they do have a notice required at hire too. So
Yes, they do. Yep.
so if they were in Florida or New Hampshire, well, New Hampshire has a notice, so that's a poor example. But if you were in a state that didn't require it, in terms of where that employee was working, then you wouldn't have to follow the New York rule necessarily. But with the example of California, then you've got a whole other bunch of things that those employees will need to receive and be in compliance with.
Yeah, and it's very similar to the New York one. So my recommendation is to pull up both of those side by side, and you'll see you have to provide something regardless. So if you're not doing any kind of notice of pay now to your employees in California, take a look at that, because they have, as Paul said, your own template and your own form and requirements that have to go in offer letters in the state of California.
Certainly that's our wheelhouse. We work with so many businesses that have expanded either during COVID from a remote standpoint or otherwise that are in multiple states. So that's one of the things we specialize in is working with businesses who find themselves trying to comply with several states, including some of the tricky ones like New York and California. So feel free to reach out on that. So looks like those are the questions that were general enough for us to answer here in the session. With that, I want to thank Melissa again. She did a stupendous job putting our presentation together and delivering some really insightful and really important news to the audience here today. So thank you so much, Melissa. It was a pleasure presenting with you.
My pleasure.
Yeah, and I'll hand things back over to Brianna.
All right, thank you, Paul and Melissa. To learn more about MP's full service solutions for 2023 and more, I just dropped a link in the chat that will connect you with an MP team member. You can also visit our website at mp-hr.com for more information. Be sure to join us for our upcoming webinar, Revolutionizing Recruitment, Unleashing the Power of Talent Acquisition. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar with the presentation slides this afternoon. Thanks for joining us and have a terrific day.